Good morning. Not legal advice, of course. Like, subscribe, proscribe, or inscribe. In the background, again, Lady Face Mountain, somewhere around here. So if you look at it, theoretically, it looks like, it's out right behind my head. It looks like a lady lying down. I think that's what you can see, but maybe you can't see it. So today's joke, I saw an ad for burial plots. I thought, that's the last thing I need. Thanks again, little Bruce T, for that wonderful joke. We've all heard about the term, I think we've all heard about it. You've heard about the term deposition in a legal process, and I kind of wanted to explain what that is and what it's used for. So a deposition is a tool that's used in lawsuits. It's a tool to kind of find out what someone's position is and to lock them into that position. And it's a tool that's used in the process that's called the discovery process. In terms of a deposition, it occurs after the complaint is filed. And after the complaint is filed and someone wants to move the case forward, they can do that through various means of discovery. One of those is a deposition. And in a deposition, you can force the other side to appear for testimony under oath, and you could get them to produce documents in response. So they come in and they produce documents beforehand, and then you question them about documents and about their story. And that's kind of how it works. So if it's the plaintiff or the defendant, you can send out a notice to the other side, and that can set the hearing, although there's usually some agreement in terms of when it will occur. If it's a third party, so if it's somebody unrelated to the plaintiff and defendant who has information somehow related to the case, to get them to produce documents and to appear, they have to be subpoenaed. So a subpoena is created and sent out to a process server who then physically serves the person who wants to be, who the deposing party wants to depose. But either way, if it's a notice or a subpoena, if the witness is properly served, they then become, quote unquote, the deponent, and that deponent is now subject to the jurisdiction of the court hearing the case. So if the witness if they've been properly either notified or subpoenaed and they don't appear, you can go in and get a court order for their appearance and get monetary sanctions against them. And those will escalate if that continues. At a traditional deposition, you have in attendance the witness, one witness generally, often counsel, their attorney, who's representing them, a court reporter who's taking down what is said, the questioning attorney who might, if you're thinking about it, that would be the opposite side on the dispute. The other side, so the questioning attorney and his client also might be there. There may be other people too. The deposition could be videotaped. There may be other parties that are party to the lawsuit. So sometimes there are many, many parties and people that are there. All are sitting around. Let me kind of take you to that point. The witness is given the same oath as if they are in a court of law. They're under the same penalty of perjury. They're given a series of instructions on how to answer, just general instructions. For example, they will be told not to speculate because you're not obliged to speculate, and speculation can't be used. You're told to wait till the other person finishes their question before you start, because the court reporter can't take down two voices. You're given the opportunity to take breaks, to ask for them, etc. But those kind of rules are laid out. Unlike like at a courthouse, however, depositions usually occur at an office. So often they'll most likely occur at a conference room, at somebody's law office. So the witness is given oath, they're under penalty of perjury, and the deposition begins. So the deposition itself, the questioning lawyer, if that's the case, and that's generally the case, will ask a series of background questions that most people would think were completely unrelated to the subject matter of the dispute, but the kind of the breadth of what you're asked or permitted to ask for in a deposition goes beyond just the subject matter of the case and your knowledge of the subject matter. So they could ask about your education, employment history, and again, a whole series of questions that most people would think, are completely unrelated to the dispute and realistically shouldn't be asked. But for the purposes of depositions, they're permitted. Now, when a question is asked, let's say the defending attorney, so the deponent is there and his attorney, we'll call that attorney the defending attorney. That defending attorney can object to certain questions. Most of those objections are just to preserve the record. So you're making an objection. There's going to be nobody issuing a ruling on the objection because there's no judge there. But if you get to trial, and should you try to introduce that testimony and you have stated an objection, then you've preserved that objection for trial and you could reassert that objection at trial. And that's basically what most objections are at a deposition. Additionally, people are trying to lead their witness. So they may be objecting and trying to, without saying it, they may be trying to direct the witness. And sometimes there's questions attorneys will just direct their clients not to answer for various reasons. Maybe they're attorney-client privilege, so they relate to discussions between an attorney and client, and those are absolutely privileged. Or sometimes the attorney doesn't want the client to answer and may instruct him not to answer, and even though that would be technically an inappropriate objection, it's done, and then there can be litigation related to that. So we have a deposition, and in California, I think each deposition per person is limited to 8 hours, which is a lot, by the way. 8 hours of questioning is a lot of questioning. But after the deposition is completed, it's typed up into a booklet form, it's sent to the witness. The witness can then review it and make any changes. But they're warned before they start the deposition. I think I indicated some of the instructions. One of the main instructions is give us, your best answer. If you don't know, say you don't know. If you change answers substantively in the future, that can be commented on at trial. It may impeach your credibility and may hurt your case. So, after your deposition, you're given the transcript and you can make changes, but if you make substantive changes, those can be commented on, and it does impeach your credibility. And the transcript itself can be used in all future filings, so you could, if it's appropriate, because there's certain motions, and at some future point in time I'll discuss motions for summary judgment, for example, but there's some motions where the deposition testimony would be relevant and you would actually physically either cite it or attach it, and probably both. So the deposition transcript can be used in other filings. It also can be used at trial. So you might form your examination based upon how they testified. So if it's my client, I may look at the deposition, see the question and answers, and form my direct examination around that to kind of keep it consistent. It's also the case that if the testimony, and I'm sure this must be really exciting stuff, if the testimony is inconsistent with the trial testimony, then you can show the transcript and you can actually cite the inconsistencies in trial. And again, you're just proving that someone's not a credible witness. And if it's in front of a jury, it obviously has more power because you're basically showing how the witness has testified inconsistently in front of the jury, and they therefore then have less willingness to trust the testimony. So that's kind of like the basics. You've heard the concept, so now you kind of know generally what it is. It's oral questioning in an informal environment that can be used at trial under penalty of perjury. It's really an important tool for lawyers. Doesn't allow witnesses to get out of answering questions, and it's a way of attorneys preparing the case for trial, and it's often a tool for resolving cases, because once the testimony is on record, then parties are much more likely to resolve matters, because now they're stuck in positions, and often they make mistakes, and those mistakes kind of help resolve things. So hope that helps you, and now when you hear the term deposition, you'll know what that means. And again, Ladyface Mountain behind me. Have a great day, be well, take care.